Welcome to Roman Manor. This lesson will provide a basic introduction to criminal law. We'll provide an outline of the typical 1L CrimLaw course and cover some topics best covered in an introductory fashion, such as this one. A word of caution. This course is intended to answer academic questions only. These materials are intended to reinforce your legal education or to satisfy the curious layperson, not legal advice. And with that, let's get to it. This lesson's purpose is to introduce you to some basic concepts found in CrimLaw, and to prime you for a more in-depth look at the elements defining various crimes. This lesson will proceed as follows. We'll begin with a subject matter introduction to the 1L CrimLaw course before briefly examining its most common theories of punishment. We'll look at the various categories of criminal laws before introducing the 4 basic elements of a crime. We'll then conclude with a look at the Doctrine of Merger. Okay, let's discuss the basic outline of most criminal law courses in law school and go over a few crim law basics. Criminal law is taught in the second semester of the student's 1L year. The course usually begins with a survey of criminal law's philosophical underpinnings, with a cursory lesson on the various philosophies of criminal jurisprudence. But this will not be the focus of your course. Nonetheless, we'll give a very brief overview of those concepts. Next, the course examines the basic elements of a crime before delving into the various criminal offenses themselves, each of which is examined from the perspective of the common law and the model penal code. The course usually concludes with a look at the justifications and defenses to the crimes covered. Criminal offenses are codified by the legislatures of the individual states. The origin of these offenses is in the common law, which is also the foundation upon which our legal understanding is built. Modernly, most states have expressly abolished common law crimes, choosing instead to reduce these common law concepts to statute. This ensured the application of the state's criminal law was uniform across the state itself. In contrast to the states, the federal government never used the common law in regard to criminal acts. It always defined criminal acts with statutes. Following the Revolution, America retained its British common law heritage. Therefore, the offenses studied in a 1L crim law course are limited to what's found in the common law. These regard crimes to one's person, spanning homicide to rape, crimes to one's property, from theft to arson, and the inchoate crimes, solicitation, attempt, and conspiracy. Most crim law classes also teach the model penal code, also called the MPC. The code was drafted in 1962 by the American Legal Institute, and it provides what its title implies: a model code suitable for the states without the messiness that often accompanies the common law. The videos in this playlist will discuss the basic elements of each crime studied as understood by the common law and the MPC. With that, let's take a look at the jurisprudential theories underpinning the state's extraordinary power to punish criminal acts. Historically speaking, there have been several theories of punishment used to underlie the uniquely severe punishments available to the state in the criminal law. Whether it was in the name of the king or the state, the criminal justice system had, and continues to have, the power to take the property, the liberty, or the life of the accused. The immensity of this power, as we said, is unique in criminal law. So let's briefly look, in no particular order, at some of the more prominent theories used to justify this state of affairs. Those that advocate for the incapacitation theory believe offenders must be prevented from committing further crimes by removing them from society. The removal can be temporary or permanent and is usually achieved through incarceration. Historically, some societies, such as Great Britain, exiled convicted criminals to penal colonies, the most famous being Australia. The overarching goal of the incapacitation is to remove the most dangerous offenders from society in order to prevent the commission of crimes in the future. Deterrence advocates believe that society should punish offenders so as to persuade others and the offenders subject to punishment that the cost of transgression outweighs any of its benefits. Usually, this is achieved through incarceration, fines, and the elimination or revocation of privileges such as holding a valid driver's license. Rehabilitation is purposed toward identifying the reason why the offender committed the crime he committed. and building skills and behaviors to address that reason, with the aim of producing a more productive and behaviorally healthy individual at release. Perhaps the biggest obstacle to implementing this approach is the number of resources needed to achieve positive outcomes. But data suggests it is the best way to prevent recidivism upon release. Modernly, and for a variety of historical reasons like the war on drugs and the anti-crime measures of the 1980s and 1990s, the U.S. has largely abandoned this theory of punishment. Retribution is the opposite of rehabilitation. It is similar to deterrence, but is distinguished by degree. The retributive theory of punishment seeks to punish the offender, to deter recidivism, and to assure both his victim and society that the offender is being punished. In doing so, the criminal justice system demonstrates its power to the offender, who is often incarcerated, fined, stripped of all privileges, and in the case of felons in the United States, left permanently unable to vote or legally own a firearm, while simultaneously demonstrating its power and quote-unquote effectiveness to the society demanding the offender's punishment. Consequently, the long-term effect on individuals and the societies they inhabit can be highly negative. Nonetheless, this is the dominant theory of punishment in the United States today. Criminal law possesses a particular taxonomy classifying the acts it prohibits. Consequently, it is helpful to have a clear understanding of what the more prominent categories mean. Common law crimes are divided into two categories: misdemeanors and felonies. Traditionally, treason was a common law crime. However, modernly, this is a matter left to the federal government. A misdemeanor is considered a lesser offense in the common law criminal scheme. It is a crime punishable by less than 1 year of incarceration. A felony is considered a greater offense, and traditionally included crimes like murder, rape, and treason. A felony is a crime punishable by at least 1 year in prison or death. Jurisdictions often create various classes or degrees to further subdivide misdemeanors and felonies. Criminal law also recognizes the dichotomy between why an act is prohibited. The concepts demarcating the two are called malum in se and malum prohibitum. Black's law defines malum in se, a Latin phrase meaning evil in itself, as, quote, a crime or an act that is inherently immoral, such as murder, arson, or rape, unquote. Black's law defines malum prohibitum, another Latin phrase meaning prohibited evil, as, quote, an act that is a crime merely because it is prohibited by statute, although the act itself is not necessarily immoral, unquote. An example of malum prohibitum is speeding while driving or fishing without a license. Now let's take a look at the basic components or elements of a crime. Under both the common law and the MPC, criminal offenses are composed of 4 elements. These 4 elements are: 1. The actus reus, also called the guilty act. 2. The mens rea, also called the guilty mind. 3. Concurrence. And 4. The harmful result, also called causation. To prove the existence of a criminal offense, a prosecutor must prove each of these elements exists. She must also prove that each exists beyond a reasonable doubt. For now, however, we'll leave matters of criminal procedure to a separate lesson. Each of these elements is discussed in depth with their own videos. Black's law defines merger as, quote, the absorption of a lesser included offense into a more serious offense when a person is charged with both crimes so that the person is not subject to double jeopardy, unquote. Naturally, this concept is understood slightly differently under both the common law and the model penal code. Under the common law, if the accused engaged in acts constituting both a felony and a misdemeanor, the accused could only be convicted of the felony. In other words, the court regarded the misdemeanor as being merged with the felony. The general rule in American criminal law is that merger as understood by the common law no longer exists. However, there are 2 major exceptions to this rule. The inchoate crimes of solicitation and attempt both merge into the completed crime. For example, if someone solicits another to commit the murder of a third person, and the solicited person accomplishes that act, the solicitor cannot be convicted of both crimes. Instead, the soliciting person would be charged with murder, the act he asked the other to complete. This also applies to attempt. The actor cannot be convicted of both an attempt and the completed crime. Instead, the steps constituting the attempt merge with the completed crime, and the actor is held accountable only for the successfully completed crime. This rule does not apply to conspiracy. If someone conspires with another to complete a crime, and the conspiracy's aim is successful, then the conspiracy's participants can be convicted of both the conspiracy itself and the illegal act at the center of the conspiracy's purpose. For a more in-depth discussion regarding the inchoate crimes, look for that video on the channel. This rule exists to prevent issues regarding double jeopardy. Lesser included offenses merge into the greater offense. An accused, once placed in jeopardy of either offense, cannot then be later retried for the other offense. A lesser offense is one that consists in its entirety of some but not all of the elements constituting the greater offense. Alright, so in this lesson we covered a short subject matter introduction to the 1L CrimLaw course before briefly examining its most common theories of punishment. We looked at the various categories of criminal laws before introducing the 4 basic elements of a crime. And we just covered the Doctrine of Merger. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.